we'll get started. Good evening, I'm Gloria Reed, co-president of the League of Women Voters of the Rochester Metropolitan Area. The League is a nonpartisan political organization which encourages the informed and active participation of citizens in government and influences public policy through education and advocacy. The League is not limited to women. Men can join in the fight as well. On behalf of all the members of the Rochester Metropolitan Area League of Women Voters, I'd like to welcome you to our March Forum, the grand jury system, who, what, where, when, why, and how. We are proud to present this panel discussion on this important issue, and we are especially pleased to be able to offer a question and answer segment following the presentations. We request, of course, that all our guests respect our panel, our hosts here at Asbury First United Methodist Church, and the League's own commitment to civil and respectful discourse. And now it's my pleasure to introduce our distinguished moderator this evening, the Reverend Lawrence Hargrave, Pastor of Outreach and Community Connections at Asbury First United Methodist Church. Thank you.
Good evening. For some of you who don't know Asbury, we are a church. And we are a church where all are welcome. So take that as an invitation if you don't have a church home. We do a lot for this community. You hear about almost daily the issues of poverty, and we do a lot for poor people. In our building over here, we have a storehouse where we supply clothing for 6,000 families over a year's time. In our next building over here, we do short-term housing for homeless families as part of the RAIN program. And in the lower level, we feed 3,000 hungry souls per month. Basement of this building, we have a free clinic for those who do not have health insurance every Thursday from 6 to 8 p.m. We do a lot rather than being just what some people think our church. And one of the things that we've been doing of late is hosting conversations around issues of the day. And I am one who believes that even if you're not a church person, if there's not a place that you can have a calm, respectful, civil discussion, one place I'm convinced and convicted should be is the church.
Amen.
You got a church man? So with that being said, I will introduce our two speakers and they'll present, and then we'll have some time for questions and answers and conversations. Our first presenter will be District Attorney Sandra Dorley, who was elected in 2011. She's the first female district attorney in Monroe County history, and prior to assuming the office, worked as a prosecutor for over 20 years. She doesn't look like she's been around that. She's recognized nationally as a leader in the prosecution of cold cases using DNA evidence, like you see on TV. And a recipient of dozens of awards, including the Robert M. Morgenthau Award. In addition to her duties in law enforcement, she's a member of a number of different organizations. She is a graduate of the Syracuse University School of Law and currently lives with her family in Webster. Roger Bazile received his bachelor's degree from the State University of New York College at Oneonta. He attended Albany Law School, where he was a member of the Law Review. After graduation, moved to New York City, where he worked as a staff attorney for the Legal Aid Society. He eventually became the director of the Legal Aid Society's Parole Revocation Defense Unit. He co-authored the New York State Defenders Association outline on parole representation. In 1989, we were blessed to have him move to Rochester, where he took a position with the Monroe County Public Defender's Office. He's worked in that office as an appeals attorney, trial attorney, and supervising attorney for the past 25 years.
And looks good.
I won't comment on that. I will say that we had a conversation about who's going to retire first. He is a guest lecturer at Syracuse University School of Law, and I am pleased to have these two very knowledgeable representatives of our New York State law. And so, on that note, would you please welcome District Attorney Dorley.
Fantastic, I love the microphone. Can everyone hear me? Yeah. This afternoon, I actually had the privilege of being with these two fine gentlemen, and we were down at the XXI studio with Ed Dawson, and we did sort of a little preview of the grand jury system and what we hope to accomplish here this evening. What I thought would be helpful is just first of all going over the grand jury process for you and explaining it to you. I think when I come out and I speak to members of the community, people who haven't served on grand jury or who haven't been through the criminal justice system as attorneys, they may not be familiar with the process. So I want to just explain that to you. And then I would really love for us to get to the heart of it, which is the question and answer period, because I think there are so many questions and so many that you have and so many answers that we can provide. So let me just tell you a little bit about the DA's office. We have 81 attorneys, a total staff of 140. It's a very large law firm. On any given year, we deal with approximately 20,000 misdemeanor cases and close to 5,000 felonies for any given year. In 2014, our office took in 4,716 felony investigations. So those are a lot of cases that come before us. But in New York State, in order for anyone to be prosecuted on a felony, it must go through the grand jury, and that's why this process is so important. There are ways that an individual can bypass the grand jury process. It would be something that you may know as a plea bargain. But if someone in New York State is charged with a felony and everyone is in agreement, the judge, the prosecutor, the defense attorney, and the defendant, they can go right to court, plead guilty, receive a sentence, and carry on that sentence. That is called a waiver of indictment. That waives the grand jury process. All other individuals who are to be prosecuted on felonies in New York State must go through the grand jury process. So here in Monroe County, we have 2 grand juries that sit 5 days a week. One grand jury sits 5 days a week for 4 weeks. You are selected for that as you are for any trial jury. Your name is picked from a hat. You are given a summons, a party invitation we like to say, and you come down and you are seated on a grand jury. So grand jury 1 is a full-time grand jury. Again, 5 days a week for 4 weeks, that's their term. We have another grand jury 2, which is a little more user-friendly to those of you in the work world. You only need 3 days a week, so you've got some flexibility. So those grand juries, they stagger, but there is always a grand jury in session so that we can present those felony cases to a grand jury for their review. A grand jury standard is different from a trial standard. Everyone knows that if a person goes to trial, they must be convicted by proof beyond a reasonable doubt. In a grand jury, the standard is different because it's the vehicle by which the person is actually charged and then brought before a superior court. So the standard is reasonable cause to believe that the felony has been committed. So it's a much lower standard. So what would typically happen if someone was arrested, say, by the Rochester Police Department for a rape, a robbery, a murder, so on and so forth? That case would be presented to a grand jury. The grand jury would hear evidence. There is no defendant in the grand jury. There is no judge in the grand jury. There is no defense counsel in the grand jury. It's just the prosecutor, 23 members who are chosen for grand jury duty. So the prosecutor will bring in a witness. There will be an exchange where facts are disclosed. The prosecutor will then read law and then leave the room. And the grand jury will decide whether or not there is a reasonable cause to believe that the individual committed the felony. If they find that there is a reasonable cause to believe, the grand jury will hand up a bill or an indictment. And that thereby becomes the vehicle by which the person is tried in superior court. A defendant has an absolute right to testify before a grand jury, but that notice has to be given to the prosecution. And also the defendant has the right to offer witnesses. So if a defendant wants to present certain facts to a grand jury, they may ask the grand jury to consider X, Y, and Z. The grand jury would vote on that, and that would become part of the record. When a grand jury comes into Monroe County, the grand jury is given instructions by a judge. We have Judge Pampiano here, and Judge has impaneled many a grand jury where the judge will go over all of the legal instructions and the legal ramifications and the duties of the grand jury. The grand jury will then come in and hear these particular cases. If a grand juror decides that there is not sufficient evidence to charge someone or indict someone with a crime, they will issue a no bill or a no cause for action. Once a no cause or a no bill is issued, the case is sealed and the person cannot be tried again on that offense unless we receive a court order. So that's kind of the nuts and bolts of the grand jury process. So let's talk about transparency. If anyone has read, I did a speaking out piece in the newspaper, I think it was a couple of weeks ago, in light of everything that's going on in Ferguson and the Eric Garner case in Staten Island, and this grand jury process that has been in place for a very long time, and Mr. Brazil will tell you about it. It's being looked at again, and the question is, what can we do? Does it need to be fixed? And I, as your district attorney, I think it does. I think there needs to be more transparency. The grand jury is a secret proceeding, which means that you cannot talk about what occurred within the grand jury room. If any of you have sat on grand jury duty, one of the instructions that Judge Pampiano would give you is that you cannot divulge what occurs within the grand jury because it is a secret proceeding. Yes, that veil of secrecy is needed, but there also needs to be some transparency. For example, when the no bill or decision not to charge occurred in Ferguson, the district attorney was able to get up in front of a bank of cameras and he was able to talk about the proceeding, talk about the facts, talk about the evidence and the law. In New York, we are forbidden from doing that. What we need is more transparency to be able to report back to the community if there happened to be an incident involving, just say, a police and an unarmed citizen encounter, and a grand jury determined or issued a no bill. I would want the law to allow me to get up and address the community of which I represent. Right now, the DA's Association of the State of New York, which there are 62 counties in the state, there are 62 of us elected officials, there's something we actually agree on. And if you know, it's very difficult for 62 people to actually agree on something. We all agree that there needs to be more transparency in the system. We all agree that the law needs to be amended and we need to be given the opportunity to be able to issue a letter or be able to speak about a no bill to ease the conscience of the community. We've sat down with the governor. We also agreed to some of the proposals that he has put forth, and one is a special monitor, which is a check and balance. What the governor's proposal is, and we're again working on just the language of the legislation, is to have a special monitor appointed by the governor. This special monitor would be in a position to review the grand jury proceeding involving police and unarmed citizen encounters that result in a no bill. It would be a check on us to make sure that we are fulfilling our ethical duties and presenting the right evidence and the right law to the grand jury. If the special monitor found that we were not fulfilling our obligations to the community, that case could again be presented to another grand jury with a special prosecutor. So that's something that we as a District Attorneys Association are agreeing on, and we're currently working through the legislation. We believe that those steps, the ability to issue a report or a letter, and the ability to have the special monitor review our work would add to the transparency of the grand jury proceeding. The only thing that all of us DAs are certain of is the secrecy in terms of protecting the witnesses and victims of crimes. And that is the key for the secrecy of the grand jury, one of the reasons for the secrecy of the grand jury. And there's something that I said, and then I'll end with this. In this community, and this is a great community, and there are very good people, but very bad things happen in their neighborhoods, on their streets. And sometimes it's very difficult for people to come forward and tell us what they saw and actually contribute to the criminal justice system. They are in fear of retaliation, and that retaliation is real. So we need the veil of secrecy of the grand jury to allow us to bring them in, to testify, to offer evidence to the grand jurors, to secure these indictments, to make sure that we can prosecute the worst of the worst and the most violent offenders and get them off the street. So again, it's a balancing effort. We need to really increase the transparency, yet as a prosecutor and as a district attorney, we need to really protect the integrity of our victims and witnesses and make sure that we can protect the community. So with that being said, I will turn the microphone over to Roger Brazil, and I welcome your questions at the end of this. Thank you.
I want to thank the League of Women Voters. I'd like to thank Asbury first. When we first discussed this, it was decided that I would speak about the history of the grand jury. And I thought to myself, if I'm going to speak for 10 minutes about the history of the grand jury, I hope they serve coffee. Okay, it won't help. But let's talk a little bit about it, because we are in a situation in our state where the right to grand jury indictment is guaranteed by our state constitution. It has become an institution which is almost unmovable. Any history buffs out there, you want to mark down this on your calendar, June 15th of this year, the 800th anniversary of the signing of the Magna Carta. So we had our little pie party 2 weeks ago. We can have a Magna Carta party. The Magna Carta is a great document, not exactly adopted in the most upfront way. The way that I heard it was that the Lords basically kidnapped the king and said, sign this or we'll kill you. And he did sign it. The grand jury, most legal commentators sort of trace back the grand jury to the Magna Carta. Actually, there are some who actually go a little bit before that, all the way back into the 12th century. The king was trying to extend his control over England because it was broken up into a lot of feudal fiefdoms. And each fiefdom had their own court system. The churches had their ecclesiastical courts, and the king wanted to have his courts. And the real reason was the courts got collect fines, and that paid for things. So for extending in order to extend the king's power, he set up courts in all of the different shires, and they have judges going from one town to the next. There wasn't enough cases to keep a judge in one place for a very long time, so he wouldn't come back for 6 or 12 months. And the king ordered a group of men to basically act as the sort of snoops of the community, and then report to the judge anybody that's committed a crime or done anything over the last 6 or 12 months when the judge was out of town. And that became essentially a grand jury of sorts. They brought charges, and the person was then tried in front of the court. Ironically, the idea of grand jury secrecy that we're going to be talking about a lot tonight originated from this, because the king would actually fine the grand jurors if they didn't indict people, or if they didn't indict enough of them. And they weren't called grand jurors at the time, they were basically appointees of the king. But they didn't want to be responsible for not indicting enough people, so they became a secret body. And that's where grand jury secrecy started from. After the Magna Carta, instead of being a mechanism for extending the king's power, grand juries became a kind of buffer to protect primarily the lords from the king's power. Because now this body of lords, of citizens of the community, would decide whether or not there was enough evidence for the king to prosecute, or the sheriff to prosecute someone. And that's really where the idea of a grand jury came from. A body that would listen to the accusations and decide, is there really even enough evidence here? Is there enough fire behind this smoke to actually hail this person into court, put him in jail while he's waiting for his trial, and then put him through the ordeal, literally the ordeal, of a trial. That's where the grand jury started from. That's what we hold up as our model, a protection from an overzealous prosecution. That's not what we have today. That's what we had 600 or 700 years ago. The world's a different place now. In fact, England doesn't have grand juries. They abolished them about 90 or 80 years ago. We still do in many of the states, but not all of them. In New York, as Mr. Orley indicated, you cannot be tried on a felony charge unless a grand jury has indicted you. But there are plenty of other states, about 22, 23 other states in the Union that don't require any grand jury vote or grand jury indictment in order to be tried on a felony. This is one of the very few rights that was guaranteed by the Bill of Rights, which is not incumbent on the states. I don't know if everybody understands that, but the Bill of Rights was the first 10 amendments to the Constitution. It was supposed to govern the federal government. It was a check on the federal government's power. And the 14th Amendment said those rights that are guaranteed by the Bill of Rights are going to be incorporated into the 14th Amendment, and they're going to become binding on the states. And there were a number of Supreme Court decisions over the years deciding, is this right, the right to counsel, the right to a trial, the right to a jury trial, all of these guaranteed by the Bill of Rights became binding on the states as well. One exception, grand jury indictment. It's guaranteed by the Fifth Amendment, and you can't be tried in a federal court without a federal grand jury, but it is not binding on the states. They decided, we'll let the states figure out their own systems and see if it works any better than what we've had. And that's where we are today. We have a grand jury system in New York. It's been in the news a lot in the last several months, both in New York and elsewhere in the country. And there is voice among a lot of people of a certain amount of dissatisfaction with the way that the grand jury decides things in this kind of secretive body without people really understanding what happened. And some of the proposals that we're going to be talking about tonight deal with trying to lift some of the veils that cover the grand jury procedure and hopefully show people that the grand jury is acting in a fair and just manner. Mr. Orley spoke about one proposal that Governor Cuomo has. Actually, as I researched for tonight's program, I spent a lot of time reading newspaper articles. And in fact, Governor Cuomo has sort of morphed his proposals and still says as of last week that he hasn't reached a final proposal as to his grand jury reform. One of the things that he wanted to do originally was to require that in all cases involving a police officer, civilian homicide situation, that it be prosecuted by a special prosecutor. He has since abandoned that position. The position that he's most recently adopted is the one that the District Attorneys Association, that Ms. Dorley has just spoken about, the District Attorneys Association has embraced, and that is let the county prosecutor present the case to the grand jury and let him write a report if the grand jury decides not to indict the person. Let him, the prosecutor, write a report and have that reviewed by some special monitor. Not quite clear what that is exactly. And then that monitor can decide, based on this report presumably, whether the case should be represented to another grand jury by means of a special prosecutor. I don't know how that's going to work out. It seems kind of cumbersome to me. Another proposal is one that's made by Judge Lippman, the Chief Judge of the highest court of New York. And his proposals are basically twofold. One of them is, in the grand jury as it stands today, basically you have 23 grand jurors, you have a stenographer, you have an assistant district attorney, and you have a witness. And that's pretty much all that's in the room. When the defendant testifies, his lawyer can sit next to him. I always, when I tell a client what my job is when I go into the grand jury, I always point to like a plant in the corner and I say, that's me, I'm the potted plant. Because I'm not allowed to ask any questions, I'm not allowed to object to any questions, I'm not allowed to do anything other than sit there and hold my client's hand. But that's only when the defendant testifies. Otherwise, there's nobody else there except for the prosecutor and the grand jurors and the witness. And what Judge Lippman is proposing is, let's put a judge into the grand jury and give this some greater air of objectivity. Because part of the concern that's been voiced by a lot of people who are critical of the grand jury decisions that we've had recently is that, and it's no secret, I mean, the police and the prosecutor's office work very closely together on a daily basis. I mean, they, particularly in smaller counties, they all know each other and their families and so forth. It is not the most conducive atmosphere for a full and fair hearing of the facts. And placing a judge there who presumably will be a little bit more independent of law enforcement than the district attorney would, could lend a little air of objectivity to the matter. That's at least Judge Lippman's proposal, part of it. The other part of it is, and this is not limited to just police, civilian homicide matters, but basically any case which has generated substantial public interest, on the one hand, and the subject of the grand jury investigation is already, the identity of that person is already known, like for instance in the Staten Island case involving the individual named Eric Garner. Everybody knew who the police officer was that was being investigated. His name was published in all of the papers before the case ever went to the grand jury. His face was on YouTube for, and seen by millions of people. So there wasn't any secret that the grand jury was looking into his situation. So if you have a case that's got a high profile, a lot of public interest, and the identity of the individual investigated has already been disclosed. A judge may release, according to Judge Littman's proposal, redacted transcripts, redacted in the sense that the witnesses' names will not appear, but transcripts of the witnesses' testimony, and most importantly, or more importantly, a transcript of what charges the grand jury, what charges the prosecutor recommended to the grand jury, because once the evidence is presented to the grand jury, the district attorney is supposed to read the law to the grand jurors and say, you may consider these charges, A, B, and C. And one of the concerns of the case with Eric Garner, the Staten Island case, was nobody knew for certain what charges were actually presented, what did the grand jurors vote on, because you ranged from intentional murder, which is the most serious crime, to manslaughter in the first degree, manslaughter in the second degree, and criminally negligent homicide. There's 4 different choices that might have been applicable to those facts. We don't know whether the district attorney in that case gave the grand jury all of those choices or asked them to simply vote on one of them, because we couldn't get to the grand jury minutes. And in fact, there was a lawsuit that was brought by the New York City Public Advocate, the New York Post, the New York Civil Liberties Union, and the New York City Legal Aid Society, and a 5th person whose name is escaping me, trying to get those transcripts from the Eric Garner grand jury proceeding released. The decision just came down last Thursday, and the judge said, no, you haven't made a showing of a particularized need as to why you need to have these minutes released, not just because it will be a good idea or everyone's interested in it, but you have some particularized need. So we don't know what the prosecutor in that case presented to the grand jury. We don't know what the grand jurors voted on, and that is part of what some people are concerned about, and one of the things that Judge Littman intends to address in the proposal that he made for grand jury reform. And actually, just to tie those 2 pieces together, I believe Judge Littman, since he's going to have a judge in the grand jury, is actually recommending that the judge be the one that decides what charges the grand jury should vote on, rather than the prosecutor. So these are all, proposals, and you know how things work in Albany. There's going to be a lot of horse trading about different bills, and